honored to appear once again before you on behalf of General Gotovina. My colleagues have addressed the evidence in this case. I shall now set forth our concluding submissions on whether the prosecution has proved its case beyond a reasonable doubt in light of the applicable law and elements of crimes. The defendant, Ante Gotovina, a high-ranking military commander, is charged with widespread and systematic violations of humanitarian law. What is at the root of this law against which this trial chamber must measure his conduct? In 1952, shortly after the adoption of the Geneva Conventions in 1949, Sir Hirsch Lauterpacht famously remarked that if international law is at the vanishing point of law, the law of war is perhaps even more conspicuously at the vanishing point of international law. In the shadow of the Second World War, Sir Hirsch was referring to the basic challenge of imposing legal constraints on the waging of war, the basic challenge of humanizing an inherently violent and inhumane activity. As Professor Kalshoven has explained, humanitarian law does not by any means purport to turn war into a fashionable and basically humane activity. Far more modestly, it aims to restrain the parties to an armed conflict from wanton cruelty and ruthlessness. Even so, war remains what it always was, a horrifying phenomenon. What lies at the root of the laws of war is a careful balance between humanitarian protection and military necessity. This balance was as relevant at the time of the 1863 Lieber Code as it is today. The former ICRC legal advisor, Louise Doswald Beck, observed that the states negotiating Protocol 1 of 1977 had this balance firmly in mind so as to codify a law that was acceptable to their military staff. To codify a law that was acceptable to their military staff. Therein lies the viability of humanitarian law at the vanishing point of international law. It is a code of conduct that is acceptable to military commanders around the world because it does not ignore the horrifying realities of warfare. It may be tempting to expand humanitarian law's scope of protection by progressively diminishing the centuries-old balance with military necessity. It may be satisfying to develop the most exacting standards that can only be achieved by the best armies fighting in the best circumstances with the best weapons, a legal utopia that sanitizes the horrifying realities of war. But a law that is unrealistic is also a law that is irrelevant. A law that is unrealistic will be ignored by the vast majority of military commanders around the world who are engaged in warfare. Military commanders without the superior training and weaponry of the armed forces of the most advanced nations. In order to arrive at a conclusion of innocence or guilt, the trial chamber must determine whether General Gotovina acted reasonably given the realities of the war that Croatia confronted. Those realities do not excuse crimes against civilians, but humanitarian law does not require General Gotovina to do the impossible. It does not presuppose that he operated in ideal or hypothetical circumstances. It does not consider whether in hindsight reality was different than how it appeared to him at the time. It does not assume that faced with grave and imminent peril, he had unlimited time and resources to train a professional army at the highest standards with the most sophisticated weaponry. All that humanitarian law demands of General Gotovina is that he acted reasonably given the realities of the war that was waged on the newly independent Croatian nation. But that is not the standard underlying the prosecution case. Throughout this proceeding, the prosecution has stretched, distorted, diluted, or simply disregarded the law. It has done so to create a standard so exacting, so unrealistic, that it would result in General Gotovina's conviction no matter how reasonably he acted. It is a contrived standard that attempts to compensate for the insufficiency of the evidence that on any reasonable interpretation must result in an acquittal. Let us consider what the prosecution's opening statement referred to as the core of its case, namely the allegation that a JCE existed to forcibly displace the Serbian civilian population through widespread and systematic unlawful shelling. At the pretrial stage, the defense Rule 72 submissions argued, consistent with ICTY jurisprudence, that whether charged as war crimes or crimes against humanity, deportation and forcible transfer only apply to territories under the actual control of an opposing belligerent. We submitted that the allegations of unlawful shelling prior to the liberation of so-called Krajina could only be charged as unlawful attacks and not deportation. In response, the prosecution argued vigorously that such a charge was not required because the definition of deportation under the laws of war is inapplicable to crimes against humanity. The prosecution then abruptly changed its position and amended count 1 of the indictment to add what we still maintain is a new charge of persecutory unlawful attacks against civilians and civilian objects. The prosecution now admits that to constitute an actus reus of crimes against humanity, shelling can only be unlawful if it violates the laws of war. But the prosecution final brief completely ignores the authorities at paragraph 860 of the defense final brief on the exclusion of pre-occupation hostilities from the law of deportation. At paragraph 482 of its brief, the prosecution persists in the theory that unlawful shelling prior to occupation satisfies the requirements of deportation. Now, consistent with paragraph 11 of its pretrial brief, the prosecution's final brief confirms at paragraph 486 that only, quote, few civilians did not flee the shelling attack, end of quote. Thus, the prosecution Brioni JCE theory rests entirely on proof beyond a reasonable doubt of mass expulsion resulting from widespread or systematic unlawful shelling prior to Croatia's liberation of the Krajina territory. Furthermore, it rests on a finding by this trial chamber that the law on deportation includes pre-occupation hostilities contrary to ICTY jurisprudence and humanitarian law. On both counts, we submit the prosecution's core JCE theory manifestly fails. Let us disregard for a moment the profound legal flaws in the prosecution theory and assume that pre-occupation shelling can be a modality of deportation. The evidence of unlawful shelling is still so grossly inadequate that one has to ask how the prosecution could pursue such a charge in this case. The prosecution's submissions yesterday conjured images of Stalingrad in the Second World War, of cities and towns reduced to rubble and innocent civilians massacred by indiscriminate shelling. So this trial chamber has to ask, after 15 years of investigation, and in view of such bold allegations, where is the evidence of this massive atrocity? Why is there no proof whatsoever that even a single civilian died as a result of unlawful shelling? Where are the photographs of Knin reduced to rubble? Why are the positive findings of the UNMO and UNCIFOL investigations simply ignored? The prosecution case is simply hopeless. There is no case to answer. But instead of doing what is right and dropping these baseless charges, the prosecution has persisted in diluting humanitarian law, in attempting to blur the boundary between war crimes and the unfortunate realities of war. At paragraph 484 of its brief, the prosecution states that civilians who were the object of the attack, as well as observers from international organizations, uniformly described the terrifying effect of the attack. In oral argument yesterday, Mr. Russo repeatedly spoke of the hours of panic and uncertainty that civilians suffered while cowering in their basement. But to point out that war creates fear, panic, and uncertainty is to state the obvious. It is not a substitute for proof of unlawful attacks. It is self-evident that neither civilians nor combatants, for that matter, particularly enjoy artillery attacks. All that this line of reasoning demonstrates is a profound misunderstanding of the exacting proof required for conduct of hostilities violations under humanitarian law. In arriving at its legal findings on the core allegations in this case, the trial chamber must consider its far-reaching consequences on armed forces around the world. Should NATO military commanders in Afghanistan stop using artillery when Taliban insurgents hide in civilian areas? Should they fear war crimes convictions, as the prosecution seeks in this case? What about armed forces without weapons capable of the same degree of precision as NATO forces? We submit respectfully that if on these facts General Gotovina can be found guilty of unlawful shelling and mass deportation, then any military commander anywhere could be held guilty. A conviction on these facts would make lawful warfare impossible. In effect, it would defeat the very purpose of humanitarian law by equating the inherent horrors of war with war crimes. There is yet another fundamental flaw in the Brioni-JCE theory. The prosecution brief admits at paragraph 482 that unless there is proof of widespread unlawful shelling, the deportation counts fail insofar as there must be proof of forcible displacement without grounds permitted in international law. But the more fundamental problem is that there is no proof even that Serb civilians fled in panic because of lawful artillery attacks.